So, good afternoon. So, I'm glad to see so many of you here and to hear the din of fun and excited and engaged conversation throughout the room. So, and we'll continue our conference on perspectives on the PTAB with a panel discussion. So please continue to eat and at this point at least talk quietly amongst yourselves if you continue to talk. But one of the things that we always try to do at events that that CPIP organizes is to have representatives from the innovation industries and attorneys speak as to their experiences and even inventors and creators about what is happening on the ground in the world. It's always good to hear, of course, from academics and theorists and policymakers. But it's also always good to have a perspective of what's occurring in the actual institutions and with the actual doctrines that we're addressing. And so we're really delighted to have three very knowledgeable individuals who agreed to speak with us in kind of an informal chat, a little informal back and forth, where I'll be throwing out some questions to them, and then they will also hopefully talk between and amongst themselves at some point, and then we will also have an opportunity for audience members to ask questions as well. So to the extent that anything has occurred to you from this morning or from anything that they remark on that raises a question in your mind, we will have an opportunity to ask of the panel. So I'm very delighted to have David Boundy, who is partner of the Cambridge Technology Law, and then Lori Self, Vice President and Counsel of Government Affairs at Qualcomm, and Rob Stern, founding director of Stern, Kessler, Goldstein, and Fox here in Washington, D.C. So I'm going to kick off our discussion by just throwing out to the panel. In the 60 years that the PTAB has been in existence, how has patent law practice changed at your firm or your company since it was established and went into effect? And we're just going to kick off with some opening remarks, and then I will ask some follow-up questions based upon that. So without much further ado, David.
Is that on? Okay. Hi, my name's David Boundy. I'm a practicing lawyer in Boston. I don't do PTAB trial work. I mostly interact with the office, with the PTAB as an appellate body after examination, and then I try to get companies going by helping getting them funded. So it's a very commercial view of it. Last night I gave a talk at the Pauline Newman Inn of Court, the group of patent lawyers that get together, and we had about 60 or 80 people there. And Bob Stoll, who was the former commissioner of patents, started his talk with a 5-minute hymn to the rule of law and how important it was and how everything depends on the rule of law. And even just describing it now, I'm a little choked up. Maybe I'm too much a lawyer, but the rule of law matters. And what troubles me most over my 25-year career is how the rule of law has just been on a gentle, slow decline at the Patent Office for at least 15 years. This morning I was just looking at the Paperwork Reduction Act, my favorite little thing. You remember 10 years ago the continuations and claims rules? I'm the guy that killed them, and it was the Paperwork Reduction Act that was the dagger. In 1997, the Patent Office ran a major rulemaking just to go through the entire 37 CFR, find rules that were creating more cost than benefit, and get rid of them. Just get them out. In 2017, no, I'm sorry, it was about 2 years ago, the Patent Office ran a rulemaking, and in the Paperwork Reduction Act section, it says, well, this is required by statute, therefore we're exempt from the Paperwork Reduction Act. That has no grounding in the statute, no grounding in the regulation. They made it up out of whole cloth. It's a direct assault on the rule of law. It's tens of millions of dollars in public cost, signed off at the level of the GC, signed off at the level of the Deputy Commissioner for Patent examination policy. It puts money in the pockets of the patent office with increased user fees, but at a huge cost to the public. It's not quite Hobbs Act extortion. People won't go to jail over this, but it's horrific. Also, yesterday I was working on a brief, just kind of at a random thing, and was looking at PTAB decisions. We all know ex parte Fry. What's the standard of proof? The burden of persuasion is on the examiner. A de novo review. Every single decision I looked at yesterday used the phrase, appellant has not convinced us that. The standard of proof is the other way. Every single judge that I looked at yesterday, this is 15 decisions, has it backwards. How can this be? At the PPAC hearing in August, Mary Lee Jenkins, the chairman of PPAC, asked David Rushke, the chief APJ, so what about this adjudicator rulemaking? Aren't you bypassing the Administrative Procedure Act? Aren't you bypassing the public vetting that's supposed to happen? And Chief APJ Rushke said, oh, just like any other judicial body, we have our precedential decision process. APJs are not judges. They don't have a presidential appointment. They don't have Senate confirmation. They can act within the Administrative Procedure Act. They can act within the Paperwork Reduction Act. There's a certain scope of adjudicatory rulemaking, but it's nothing like what the PTAB has been doing. Now, fortunately, at the end of my talk last night, a couple of the APJs came up to me and said, thank you so much for telling us. We aren't paying attention to this Administrative Procedure Act stuff. I think most of the APJs, not all of them, but most of the APJs care. They're trying to do the right thing, but it just isn't, the Administrative Procedure Act, administrative law just isn't part of top of consciousness. Right. Lori?
Yeah, so just to provide a little bit of context, Qualcomm is one of the world's leading developers of wireless communications technologies. And since our founding, we've invested about $50 billion in R&D. We make very big, long horizon bets on mobile technology advances that will take years to reach the commercial market and may never succeed. And in fact, many of our bets have failed. And so patents, if you sort of think about what is the impact of PTAB on a company like Qualcomm, I think you have to look at that broader R&D calculus, if you will. What does it mean to have an administrative body that appears to view its mandate as invalidating patents, as opposed to making an independent, neutral evaluation of the validity of a patent? That, I can't sort of speak to the direct impact on Qualcomm's decision-making today, but there's no question that you're going to see over the next 5 to 10 years an impact on R&D investments in this country if we don't start to address some of the concerns that have been raised. Also, by way of context, I will say that I, on behalf of Qualcomm, I participated in the congressional negotiations around the Inter-Parties Review statutory framework, as did David and I'm sure Rob and others in this room. And due process was unquestionably top of mind during that process. It was really my job to look at the statutory language that had been proposed and to sort of think about how can this be gamed in a way that will undercut the value and enforceability of patent rights. because you knew that it inevitably would. And so there was a tremendous amount of time and effort, really probably a year and a half, if not longer, of negotiations to ensure that there were appropriate due process safeguards that would create at least some semblance of a level playing field for patent owners. And I suppose what concerns me most about PTAB and the PTO's implementation of the statutory framework is that you see one after another those due process requirements being ignored or trivialized in a way that, again, has created this dynamic that is very unfavorable to patent owners. And David mentioned the presumption of validity. I went back and looked at my notes from the AIA negotiations, and I had a summary of the statutory framework that was ultimately passed into law. And there was a list of due process safeguards. One was presumption of validity, which essentially has been ignored. And you can point to numerous others, an estoppel effect, right to amend. It's creating a lot of feedback, I'm sorry. So you have to sort of think about, for a company that's making very long-term, large investments in research and development, we're obviously a publicly traded company, so we need to be making decisions that are defensible to our board and our shareholders. Can you safely invest huge amounts of money in patented technologies, knowing that if your patents are thrown into a PTAB proceeding, there's a very high risk of invalidation and a very meaningful risk where you won't be able to defend the validity of your patents in the same way you can in a court of law. So I can't tell you what the exact effect is today, but I'm very troubled about in terms of what the longer term effect could be, not only on Qualcomm, but obviously on any entity, firm, university, et cetera, that's driving R&D investments in this country.
So the summer of 2012, I spent writing patent office litigation, which was the first book on the topic. It was 1,000 pages. I wrote 13% of that myself, and I edited every page. It was about 40 people in my firm. And in the first chapter of that book, I predicted a lot of the things that have happened from a practical point of view, because it was so obvious, no pun intended, as to what was going to happen. We were told all kinds of things during the legislative process that did not come true. Now, having grown up in Washington, I'm pretty cynical. But the level of duplicity that occurred in the minds of many was just at a new level. And so here you are. I represent U.S. companies by and large of all sizes and shapes and universities. And the firm does all technology spaces. So there were about 4 or 5 misconceptions that have turned out to be true. First of all, we were told, and Colleen Shen and I challenged each other at IP Council Cafe back in 2012. She said, well, these proceedings will only be used against bad patents. I said, well, what are bad patents? She said, well, the patents that shouldn't have been issued. And I said, well, in all due respect, Colleen, in the real world, nobody's going to go after a bad patent. They're only going to go after a patent that's worth a lot of money potentially, or it's going to cost them a lot of money. So those are the patents it's going to go after. So it struck me that here we have this academic who thinks she understands the real world, and she has no clue how decision-making really happens in corporate America, in the venture capital community in Sand Hill Road. She doesn't get it. The second big misconception was it was only going to apply to electronics or maybe software patents. Wrong answer. We've seen how it's being applied to all technologies. Some of the most valuable patents that it's been used against are pharmaceutical and medical device patents. So that was another big misconception. The third misconception was it was only going to be done in exceptional circumstances in district court litigation. Well, as I pointed out in Chapter 1 of that version of the book, and in the second version that came out this year, that's not turned out to be the case. It's standard operating procedure in every litigation today. It's almost malpractice, to put it in the terms of a famous trial lawyer, to not bring at least one proceeding against each claim that is being asserted in court. We were also told that the judges in the district court were not going to be required to stay their proceedings. And one of the reasons why the judges had this latitude, I was told, was because there was this concern in the drafting of the AIA about it being unconstitutional. I mean, think about it. Why do we have a parallel proceeding in the district court on the same issue with the same evidence that has entirely different claim construction rules, presumptions of validity, and process? I mean, the process is entirely different. There's no live witnesses at the PTAB. They're under this one-year rule. And then the other thing that we were never told, or that people assumed, was that it was going to be faster, cheaper, and better, which in fact it's turned out to be completely false. Because the reality is that it takes another 3 years now in every case of any major significance to litigate the case to conclusion. And the only time these cases get settled now, because we've seen the impact of the PTAB on value of patents, people are saying now all over the place that the value of patents has dropped precipitously. Took a while for that to register. But the estimations are between 30 and 50% value drop across the boards. So the impact of these proceedings on patent practice in law firms and in corporations has been totally profound. And we now find ourselves in a situation where Europe and China, in fact, have more predictable, faster, cheaper, better patent systems than ours.
Excuse me. Well, thank you, and thank you for. I'm sorry that all of you held back and and didn't really tell us what you really thought and felt about what's happening on the ground. So, picking up on some of Rob's concluding remarks. Can you maybe identify a little bit how maybe advice that you're either giving to clients or discussions with colleagues has changed since the PTAB was established, and if so, how? So, David, I'll start with you again because you're a practicing lawyer, as Rob is as well. So, just interesting to hear that.
My office is.
Yeah, just move
Here?
it. Just move it closer. Yeah.
Is that it?
Yes.
I have the coolest office in North America. It's halfway between MIT and Harvard, and I get cool startups. 10 years ago, patents were an asset. We would go to the venture capitalists. They were valuable assets. Now they're not. I mean, that's oversimplifying, but Rob says that the settlement value for patents have gone down 30 to 50%. I'd say the fundraising value of patents is down 80%. If you're a startup, it's just a bloody lot harder to get financing. We've all seen, when the AIA was coming out, I said that, 5 years from now, Business Week is going to have big articles on whatever happened to the startups in the United States. It's not the America Invents Act all by itself, but that's a big factor. And it isn't just the PTAB that's a big factor. It's trying to get good patents under the new deadlines with no grace period. It's very, very difficult for startups to get good patents filed in a timely way. So the big story is I don't make nearly as much when patents are much less valuable. Patent lawyers are much less valuable, and I'll be frank about that. It sucks, but it sucks even worse for my clients. Lori?
Yeah, so just to build off of one of the comments that Rob made about the predictability of the U.S. patent system versus China and other parts of Europe, just to add a data point to that comment, the U.S. Chamber's Global Intellectual Property Center does an annual comparative survey where they look at the relative strength of different IP systems throughout the world. And this past year, the United States dropped from number 1 to 10 for the first time in the history of the survey. We are now on par with Hungary in terms of the perceived strength of our patent system. And one of the two factors that was cited by the Chamber was the PTAB system. That, in combination with changes to 101, have created this tremendous unpredictability, uncertainty that Rob and David have commented on. And again, I think you absolutely have to look at that in the context of investment decisions. I mean, what does it mean to have a patent? Well, historically, it's meant that you have an enforceable private property right that's backed by a rule of law. That's what it's meant. That foundation is fundamental to investment decisions, to your willingness as a venture capitalist or a company to make long-term bets or short-term bets. And as we diminish the enforceability and predictability of patent rights through the PTAB, through Supreme Court jurisprudence, and let me just say I'm personally terrified of the oil states case, we are moving our economy in a direction where it no longer, or potentially no longer, makes sense to direct investments towards long-term research and development. And long-term research and development is critical to our ability as an economy to achieve transformative technological developments, economic growth. I mean, look at, Qualcomm, we like to look at ourselves as sort of a case in point of the value of a strong, predictable patent system. In my view, it's no coincidence that when we were founded in 1985, we as a country were starting to reestablish the strength of our patent system. We were starting to wake up to the fact that we had diminished patent rights through a variety of different changes, and it was time to reverse course. And I think the fact that we were able, as a startup, to make huge investments in very risky technology, battling against very large European companies at the time, the fact that we were able to justify those investments and succeed and then build an incredibly valuable licensing business, the foundation of that was our patent system. And PTAB, I think, has really thrown that, again, that sort of R&D calculus into chaos, potentially. I don't know that it's deliberate or intentional or nefarious. I don't want to suggest anything. But I think within the agency, there's a fundamental lack of understanding of what it means to make huge investments in patented technology, to achieve a patent after years of negotiation with an examiner, and then to find out that the chances of that patent surviving a PTAB proceeding are, depending on the field of technology, 10 to 40%, 30% at best. I'm a policy lawyer, not a, patent prosecutor, so I tend to look at these issues through kind of a longer term lens of how do these successive degradations, weakening of our patent system, how are they impacting the ability of a company like Qualcomm to justify long-term R&D investments? And more importantly, what does it mean for startup growth in this country? Because, the goal of the patent system is to incentivize the little guy to make these investments, not just, big companies maintaining their commercial footprint. And I do worry and agree with David that we are, as we degrade the rule of law as it has historically applied to patents, we are at huge risk of severely, if not permanently damaging our startup economy.
So Bob Taylor is a very well-known highly regarded, highly experienced patent attorney and antitrust attorney in the Bay Area of San Francisco, and is also very involved with the National Venture Capital Association, and has repeatedly said in conferences that I've been at with him and in others that the startup numbers for the U.S. are down, and that the venture capital is moving outside of the U.S., and the impact on high-tech jobs and job futures is down. And Congress is starting to slowly wake up to this issue of jobs and investment and flight of capital out of the United States due to the impact of the AIA on the predictability and the actual respect given to patents on very important technologies. And we're going to see a continued trend as the data starts to continue to roll out. So the office needs to wake up to the fact that they have a huge political problem that's going to get worse and worse unless something's done now. Now, what do I do? What do I tell clients to do? Because I'm a practicing attorney, not a professional lecturer. I do this for fun, so to speak. A couple of things. First of all, I think that one of the problems lies in corporate America. There was a huge push in this so-called arms race, this numbers counting of patents that started with cross-licensing programs brought by big companies where little companies would get to pay less money if they had a lot of patents, and there was no real way to assess quality. So this cross-licensing mechanism that started in earnest about 25 years ago drove a lot of companies, particularly the large ones, to go after the largest number of patents they could get and essentially throw quality out the window. So it was garbage in, garbage out, so to speak, on the patent application side. So a lot of the patents that ultimately get asserted in the electronic side are patents that were very bare bones in their disclosure and very bare bones in their prosecution with no search done. And so you can see why those patents are extremely vulnerable to these proceedings, and maybe appropriately so, regardless of the underlying invention. Because, as we all know, your patent protection is never better than your underlying invention, but it can be a lot worse. So the first thing that I do with all startups, and frankly, any client that really is interested in protecting their ROI, their research and development costs, and their return on investment for their assets, is to put a lot more money, time, and effort into getting their patents and prosecuting their patents. In other words, writing much better specifications and coming forward with a prosecution strategy where a lot more stuff is done in the prosecution than you would historically see, including submitting evidence in the form of declarations, which was the antithesis of what you would do if you listened to my mentor, Professor Caton. You would never do that. So what we're seeing now, and this is a positive impact, is that some of the panels at the board are recognizing and acknowledging that there should be more deference given to patents that have been vigorously prosecuted, where there's a full record for the board to see. And they are not instituting, I think, in some of the cases where the prosecution was very robust and the challenger has really raised nothing new, which is a really good development for patent owners. So that's one positive development that the board seems to be embracing. The second positive development that the board is embracing is this serial attack. You know, we were very concerned with the AIA because we had experienced a lot of serial re-exams where you just keep filing and filing and filing and forever. And going back to Lori's point, that basically freezes the patent in limbo land until it expires. I mean, you can't enforce it if it's yes, you can have a race to the federal circuit like we saw in some of those early cases, but nonetheless, it just throws a total wrench into the machine. So the board seems to be exercising appropriately 325D, which allows them in their discretion to not institute when there's serial IPRs filed or multiple IPRs filed. And I've been in cases, for example, where there were 16 IPRs and CBMs filed by a major U.S. company, not a troll or whatever, but a major U.S. company against another major U.S. company, 16 IPRs for 6 patents. Think about that. I mean, why does there have to be 16 IPRs? And they were serial. They weren't just filed all at the same time. And then on top of all of that, after they lose everything, they file ex parte re-exams. Really? Do you know the cost of this is and the impact on the enforcement litigation? The last point is, thank God the ITC does not stay 337 proceedings if there's an IPR filed after the institution of an investigation. So the ITC has benefited enormously as a forum of choice where it's available due to this new system.
Rob, as a quick follow-up, your point about how there were too many bare-bone patents, regardless of the underlying legitimacy of the inventor and company that was to which it was assigned receiving the patent or not. Is that one of the reasons why the AIA originally provided for a right to amend, that if the patent happened to be legitimate, then and what they found through the IPR was a defect, then they could amend it and sustain the patent?
Yeah, I mean, I remember vividly a conversation with Joe Mattal over this very issue of you were going to have one crack at amendment almost as a matter of right. So I'm on the phone with a famous judge. This is early on. By the way, I've been in about 180 of these proceedings myself, and my firm's in about 800 of them.
Real quick, you mean by judge an AL?
Yeah, a judge at the board.
Yeah, okay.
So this is early on, and I'm being the naive person that I am. And I say to the judge, I want to amend. He goes, excuse me? I said, well, I have a right to amend. He says, you have no right to amend. And my general counsel's on the line, and she's texting me. She says, slow down, Rob. So now I'm on this, and by the way, you're not in the room with the judge. You know, you're not in the room. You're on a conference call. So imagine you're arguing something as fundamental as your right to amend, and you're on a conference call, and your client, who's in another city, she's texting you saying, slow down. So I say to this judge, it's getting very heated, and of course I don't have a court reporter, which taught me a lesson that I always have a court reporter now. So I have no court reporter, and I say, well, Your Honor, the statute says, Mr. Stern, the statute, it's called inter-party review, Mr. Stern. It's not called inter-party re-exam. It's a review. You don't have a right to amend. And I go, it's a 1-to-1. He says, no, it's not. And it starts getting very ugly. I mean, very ugly. And I'm going, wait a second. I said, well, Your Honor, this is a denial of due process, which at this point, this guy goes nuts on the call and says, what did you say? And I said, it's the denial of due process. And meanwhile, my client's going, shut up. Shut up, back up. Agree with him. So he says, Mr. Stern, wouldn't you agree with me that you do not have a right to amend and it's not a denial of due process? Yes, Your Honor. Now, everything, all the time, we hear that there's a right to amend. And I hear through my grapevine that this Aqua Products case isn't going to change it one bit. It's not going to really change it one bit. It's going to be ignored by the board. We'll see. But the point is, you can't amend. If you're going to amend, you've got to go to reissue, you've got to go to re-exam. That's where you go. You don't try to do it at the office in front of the PTAB. But that adds a couple of years of additional delay because there is no statutory time period for a re-exam or for a reissue. And they're handled by the CRU, and all of that stuff gets appealed to the PTAB too. So the idea that this is faster, cheaper, and better is not true.
So we will be taking questions in the audience in just a moment, but David also had something that he wanted to add.
Rob's little anecdote prompted the same thing. It's not just him. I had the same thing. Going up the other direction through the petitions office. Got to the Deputy Commissioner for Patent Examination Policy. I had filed a petition on Administrative Procedure Act grounds with lots of Supreme Court sites and so on. And of course, this is the Office of Petitions, so they redefined the issue that I had presented into something that could easily be denied, and then misquoted the underlying legal sources and all of the things that happen in the Office of Petitions. But there's a name at the bottom, please call this person. So I called and I said, I had cited Service v. Dulles here. Service v. Dulles says that your guidance is binding on your agency employees. It's not just guidelines. Oh. We talked for a few more minutes, and I don't remember what the other case was. It's some Supreme Court case. This is the Office of Petitions acting with the signature of the director of the Patent Office. Said, I don't remember what the other case was. Mr. Boundy, I'm not getting into the United States Supreme Court. Just the rule of law, the idea that there is an Administrative Procedure Act, the idea that the Supreme Court sets law that binds agencies, foreign turf at the Patent Office.
All right. I think I saw a hand here, and we do have mics so that people can be sure to hear you. So, Alex, if you can. Yeah. Yep. Excellent.
Thank you. Bob Weber from Patent Kinetics. There are a couple of cases that probably are extreme but are worth pointing out. One is the Zahn patents, in which 125 separate petitions were filed at the PTAB to kill, I think, between 2,000 and 3,000 claims. The other is $1 billion worth of jury verdict hangs in the balance or has been nullified in some of the Vernetics cases because of PTAB action. So I think a way to think about the PTAB is an invalid patent is a patent that's been asserted against somebody who has the resources to fight it.
Can I just say on the estoppel issue, which, again, if you kind of deconstruct the statutory framework with the IPR, one of the most contentious issues during the negotiations around inter-parties review was what would be the preclusive effect of an unsuccessful inter-parties review. In other words, the possibility of serial challenges by the same petitioner or other petitioners. And we fought tooth and nail to get a robust estoppel effect built into that statute. And it just defies reason that those types of safeguards have been ignored or flouted by the PTAB. And it's that kind of situation where going back to Rob's example, where it just is happening within this board, where they feel like they have the power to ignore statutory requirements. And now what the end result will be is new legislation. We have the Stronger Patents Act that was introduced by Senator Coons. It basically, on these issues of due process, basically says, we really mean it this time. We made the mistake of giving you discretion under the AIA. We're taking that away because that discretion has been arguably abused. So it's incredibly frustrating to hear those types of anecdotes because it just speaks to the fact that there was a lot of time and attention and effort that went into creating a balanced framework that really has been just ignored in implementation.
Yes, Dimitri. Yeah. Wait for so we can make sure everyone can hear you.
Just loud. Question for Rob, but there you go. But maybe for the whole panel too. So you mentioned that responsible prosecutors do prior art searching, right? But interestingly, in the government's brief, right, in oil states, no duty to search was sort of pointed out as a potential indication that maybe patents that issue are analyzed in a cursory way. So would it be a good idea to impose a duty to search on patent prosecutors, and would that have blunted some of the criticism that led to the AIA reforms?
I don't know. I think that if you have I tell clients that they need to have different levels of investment in their patents. I was lecturing on this back in the 80s. You've got to have several layers or levels of patents. Some that you would not search, for example. You would let the office do the search. I don't think there should be a requirement to do a search. There's no requirement at the EPO to do a search, and there's no requirement in China to do a search. So why should we do that? But I do think that it's self-help. And the idea that general counsel or CFOs come into the patent counsel's office and say, cut your budget. I want 10% more patents filed this year, and I want a 10% reduction in your budget is nuts. And I've been to Stanford Director College twice. It's very expensive, very elite, and there's nobody there with any IP knowledge. And I've asked this question twice, at each one of these events. And I've had board members of famous companies come up to me at the break saying that was a fabulous question. But Stanford Director College doesn't want to deal with IP. Here you have an organization that is advising the VCs and the directors of some of the hottest startups and emerging companies in the world. And there is absolutely no appreciation, any kind of value placed on IP. And this is before AIA. And so you can imagine what the situation looks like now. And the unfortunate thing is that most of the venture capital community doesn't get the connection that Qualcomm gets. They don't understand it. IBM gets it, but a lot of these newer companies, they just grew as fast as they could, and then as an afterthought, they bought some earlier companies' patent portfolio, and so now they have this patent portfolio, and they think, oh, good, we spent $15 million and we got 25 patents or 200 patents or pick a number. But have they really bought anything of any value? Probably not, because a lot of these patent portfolios that are being asserted by so-called trolls are actually patent portfolios from major companies that want to cut their costs in terms of maintenance fees. And they were prepared under this regime of, file as many as you can at the cheapest price. So it's a self-help world we live in, and I hope that the PTAB takes a careful look at every one of these petitions and says, what does the underlying prosecution look like, and what does the underlying quality of the patent look like? Because if there isn't deference given to applicants who really do the job right, then we really have a terrible system. Because as very famous people have said, how do you run a business where you have 9,000 people creating a product and 400 people killing it?
David?
This has been thought about for 20 or 30 years, and the problem with a duty to search is that just what's the implementation and what's the penalty? I've never seen a proposal that makes any sense at all. What we do have is kind of what Rob was talking about, which is a set of incentives. If you do it one way, you get one set of benefits. If you do it cut rate, you get a different set of benefits. And perfect. It's the right kind of a regulatory regime where you get to choose your own adventure.
All right. John?
Thanks. I actually thought that Robert's comments about spiraling down of patent quality are kind of interesting because that, I think, is something you don't hear a lot from this panel, from a panel of people who are generally favorable to the patent system. And so my question is, did patent owners resist any kind of opposition procedure or anything else that might have improved patent quality for such a long period of time that ultimately, when Congress finally did act, they went too far? In other words, the AIA might be too aggressive, but the patent owners resisted opposition procedures, which are in other countries. They resisted any kind of judicial review of the issuance of a patent grant and all these other things. And then when the dam finally bursts, it does a lot of, things go too far. So I wondered if you'd comment on that and if alternatives like immediate judicial review or pre-issuance opposition might be better than some of the things that you're criticizing. Thank you.
Well, I was given the opportunity to speak on the new law before it went into effect at Princeton, and Judge Rader, Chief Judge Rader, and Chief Judge Michel were both there. And I went through the statute because I was writing this book, and what really caught Rader's attention was my prediction on the number of proceedings that were going to be filed, which was much higher than that were being expected. So that was a big development. And so he pulled me aside and said, show me your numbers because I can't understand how you came up with such an increase in appeals to the Federal Circuit. So I showed him the numbers. And this was before we thought we were going to blow through the 400 limit per year. So you can imagine what the Federal Circuit's dealing with. So I think one of the problems here is that the Federal Circuit is overwhelmed. But going back to your point, I think that there were games being played, John. I really do. I think that there were agendas, different agendas. I think that the pharmaceutical industry was very worried about first inventor to file, so they really didn't think that these proceedings were going to apply to them. That was one thing. I think another thing was that the patent owners didn't really think that the patent office would be so tough. In fact, as the numbers came out to show, on some of those most valuable patents, I don't think they expected that. And it's a combination of factors that produce those numbers, by the way. It's, a lot of this could be corrected if you believe in the Stronger Patent Act, just by some tweaks. But I also think that there were people who were in this process who have no interest in us having a patent system at all, period. They see no value in it. It doesn't matter how high quality it is, because there shouldn't be patents. There should not be patents. They're a tax, they're terrible, they're a bad thing, and they get in the way. They get in the way of everything, and let's get rid of them. And the reason I started to think that that was the case was I overheard 3 very prominent women, experts in our field, talking to each other after my presentation saying, okay, now that we've got the AIA, let's go in for the kill. So we're standing on the railroad platform, Chief Judge Michel, Chief Judge Rader, and some others, and I told them, I said, guess what? There's more legislation coming. And they said, oh, no, there's not more legislation coming. Are you kidding me? It's a 10-year period. We're not going to see any more legislation. And the next thing you know, you have loser pays, which would have been absolutely the death knell for our system. Thank God that didn't go through. And so I think that Silicon Valley hates patents. They just hate them. And why wouldn't they? Because they're living in a bubble. I was there on Monday. There is so much money in Silicon Valley, and they're building buildings everywhere. The venture capitalists are not convinced. You almost get blackballed, I was told by some very informed people, if you're a board of director member, to bring up patents in a positive way in the Valley. I think it's an echo chamber, as somebody describes it, where everybody's saying to each other, we don't need patents. But the joke is, wait until the Chinese show up. That's my theory. Wait until they show up, and then we'll see what happens. Because let's remember what created the Federal Circuit. It's the Japanese.
So just going back to your initial question of, was the IPR framework the sort of unintended consequence of patent owners opposing any kind of opposition system? Just to reiterate what I was saying earlier, the original proposed framework for inter-parties review was actually much worse. And so, for patent owners like Qualcomm, a lot of the work that we did during the legislative fight was opposing what we consider to be sort of a blatantly unfair system and then working hard to get due process safeguards built into the statutory framework, which, arguably have largely been ignored. So I think there is a real question about, to echo one of the comments that Rob made, to what extent could the PTAB fix these perceived problems on its own without the need for additional legislation? I think it easily could. In fact, I think it's mandated to by statute in certain cases, but they've shown no desire to. And so that kind of goes to one of the issues that was discussed in the panel this morning about, has this process become so politicized that there are due process concerns or constitutional concerns? I'm not by any means an administrative law expert, so I can't, or a constitutional law expert, so I can't speak to those questions. But I will say, again, as a company that makes huge investments in research and development that can only be justified if we have a strong, predictable patent system, the politicization of these PTAB proceedings is incredibly alarming. It's not just icky, it's incredibly alarming. It's not just the structure of the process is problematic, it is the politicization of the process. And that's, that speaks to other influences beyond just what the AIA set forth through the legislative construct. Going back to Rob's comment also about China, what many of us know who follow these issues very closely is that as we, as a country, weaken our patent system through these cumulative legislative, judicial, regulatory changes. And again, for those of us who were involved in the AIA negotiation, one thing we did not predict was the Supreme Court's 101 jurisprudence, because it's that dynamic in combination with PTAB, which has been so deeply problematic. But as we are weakening our system, China is actually taking steps to strengthen patent protection in its country. So what does that mean in terms of this long-term versus short-term investment dynamic? Well, I'm happy for Silicon Valley and their bubble, but what Silicon Valley often forgets is that their businesses are built on top of technologies that are deeply dependent on research and development. And it's those kind of foundational technologies where we are at serious risk of being overtaken by China and other countries if we continue down this path of weakening the property-based incentives that have, historically justified these big investments in technology and have driven our technology leadership. And it's not going to be 50 years from now where we see the effect of this. It's going to be 5 years, 10 years. So I think that it's that broader dynamic that we need to be acutely aware of, in addition to the kind of legalities of administrative law. It's the broader economic implications that I think are often forgotten in this conversation.
I'll just make one quick correction to Rob's remarks on the history of the legislation. It was that, yes, everyone was, after the AIA was saying, all right, Congress has spoken and historical patterns are that there won't be any more legislation on it, but it wasn't, it wasn't the patent litigation bills that were next. It was actually within 8 months, there was the proposal of a technical amendment that was not a technical amendment that actually made a substantive change to the AIA on exactly the estoppel issue that Lori was addressing under the auspices of it being an alleged technical amendment. So, I mean, the fight continued, and this is evidence of that there were a lot of forces at play beyond just trying to correct the problems with existing issuance of patents and dealing with obstreperous patent owners who are resisting other changes to the patent system. But I think all of those factors were coming into play and kind of creating a perfect storm. Well, Lori's comments, was raising the issue of kind of the impact on the long-term investment in R&D and and unless I see another question in the audience, I'll throw it to the audience, or I'll throw it to my panel. What has been the immediate impact, at least in the short term, of the PTAB on patent licensing and R&D investment. I mean, I'm not asking for sharing of any particular details you can't obviously share, but to the extent that you can provide examples of how or in what way you've seen the impact of this organization or institution on the development of technology and licensing. Appreciate that. So,
Yeah, I mean, this is not, again, from Qualcomm experience, but just in talking to many others in the startup community and the VC community. I mean, again, I hear the same data points and anecdotes that David and Rob have been alluding to, that VC investments in this country are increasingly moving away from startups that require long-term R&D investments, and instead favoring the kind of Silicon Valley, social media, open source backed model that's, quick to market. And it's not as if, those types of startups are bad or good. It's the fact that we are diminishing, we are, ideally you want a patent system or a system of laws that supports both types of investments. And the fact that it's, increasingly you're hearing that you cannot get funding for a patent-dependent startup in this country means, of course, that technological development, transformative technological development will not occur in this country. It's potentially migrating to countries with a stronger patent system, including China, including Germany or the UK. And so it's not difficult to predict the implications of that. And then, of course, you combine on top of that many of the other sort of regulatory challenges that are confronting patent-based, licensing-based businesses today. Very aggressive antitrust attacks in other parts of the world, et cetera. Going back to the comment that I think Rob made about the fact that the Federal Circuit was a response to this perceived threat of Japanese dominance in important technological fields. I mean, I really do think we need to be taking a very holistic look at these issues and thinking about what policies need to be adopted to kind of restore the foundation for technology leadership in this country. PTAB is an important part of the problem as I perceive it today, but there's a broader set of policy challenges that are making it very difficult to sustain a patent-based, licensing-based ecosystem in this country.
So you don't want to be a chump. That's the word in Silicon Valley. You don't want to be a chump. What is a chump? A chump is the first person to license a technology portfolio that's being asserted across a group of companies. You do not want to be the chump. You don't want to be the first person to pay, regardless of the merits of the case. You don't want to be a chump, because what if they knock it out 2 or 3 years down the line in the PTAB? Or what if after they survive the PTAB and they appeal to the Federal Circuit, they knock it out in the district court? Or what if the Federal Circuit reverses the district court and finds the patent invalid sua sponte, which they've done? So nobody wants to be a chump. So what does that mean? Nobody settles. Nobody settles, nobody licenses. And so we have the quote, so-called efficient infringement business model. What's that? It's cheaper to pay some big fancy law firm a lot of money to fight every year until it's over and never pay than it is to grant a reasonable license fee, because nobody wants to be a chump. The law firms are complicit because they're making the money. The patent owners get what, and and then the other fear that a lot of people have is, where is the board recruiting their judges from? The firms that are engaged in defending against these bad patents. That's where they're coming from. So their whole professional perspective, was on the side of being on the defense. They weren't plaintiffs' lawyers. Not that I have any great love for some of these plaintiffs' lawyers who will assert anything against anybody, including their own mother, maybe. But the point is that the judges have this perspective that there were all these crummy patents that were being asserted against their very highly successful companies that were being picked on as targets for taxing. So you have a bias in the perception of many people on the board that, patents need to be looked at with great askance. And so when Judge Rader made his infamous comment about the death squad, one of my colleagues who was on the board pulls me aside in the lobby of Madison, and he is so upset with me. He says, "How dare you repeat that phrase in a speech, Rob? You're going to get your reputation at the board is going to an all-time low." I said, "Really?" He said, "Yeah. I mean, you can't be saying this." I said, "Well, I'm just explaining to people in my presentations, X, what our chief judge is saying." "Well, you can't be saying that. That's completely wrong." I said, "Have you looked at the data?" Now, it's true that the data is getting better for patent owners. Historically, it's moving more in the direction of patent owners. But you could also argue that the really bad patents have been knocked out. And now we're down to the really valuable patents. So when you have a system where 60% or 50% or however you want to call it of the patent claims being asserted are invalid, you don't just bring a lawsuit on an invalid patent. I mean, the way it works is in the real world, and a lot of these are company-to-company fights now, there's an amazing amount of money spent by the patent owner, who's oftentimes a big company now, before they decide to assert their patents. And the new rule is that you never go into a lawsuit with one patent. You have to go in with 4 or 5 and maybe 20 or 30 or 40 or 50 claims total just to play the averages, just to play the numbers, because it's a numbers game. So to me, it's a weird system. And, what I find so amazing is how quickly the Chinese have spun up their patent system and how strong they've made it. So ask yourself why. I mean, think about that. And the other thing I find interesting is when I go to the EPO and talk to them about this topic a lot, they kind of look upon us as a bunch of amateurs.
Can I just want to make a comment about, I do worry about this perception that, most patents are junk, especially if you think about how PTAB now operates in parallel with litigation. The fact that inter-parties review has become sort of an inevitable successor to a patent being enforced. And, building off of Rob's point, if you're a company like Qualcomm that has 100,000 patents, and I'm not sure what percentage of that are U.S., but when you go into a litigation, you have to pick less than 10, let's say. And so you're going to spend a lot of time and money trying to figure out which are the strongest, most valuable of those patents relative to the, alleged infringing product. So this notion that PTAB is all about junk patents is really, it's not kind of in sync with the reality of what patents are actually being challenged through PTAB. I mean, these are patents that have been identified as potentially among the most valuable of a company's portfolio. And then the question is, well, what is the role of PTAB? Historically, inter-parties re-exam, for all of its flaws, and it had many, in addition to, among one of the most important flaws being is it just went on forever. But one of the distinctions that I've had many patent prosecutors and people who are familiar with PTAB point out to me is that inter-parties re-exam, the end game used to be kind of narrowing the scope of the claim as opposed to knocking out the claim altogether. And I think that's an important, really fundamental distinction that needs to be drawn because, if a claim is overly broad, then absolutely it should be appropriately refined in the same way that a boundary of real property could be clarified. But to knock it out altogether, to walk away from a PTAB proceeding with nothing, is a huge loss of capital investment when you're talking about patents that are potentially reflective of the most valuable patents that a company has. And that again goes back to, well, what's the effect of that? Well, we won't know because we'll never know about the startups that didn't receive funding. We'll never know about the investments that weren't made because of this very different dynamic that we now face with PTAB.
Well, thank you. We are actually coming up at the end of our time. So, David, maybe if you have a short added comments to kind of close out our panel, I'd appreciate that. But otherwise, we want to give people a chance to have a break and take a fresh, get a breath of fresh air, maybe get out of this room, which is getting incredibly colder with each passing moment, before the start of our next panel at 1:45. So.
The biggest factor that I have is that it used to be that you would file for a patent, you'd get one issued, you might file one continuation and get a second, and then the money drain would stop after 5, 6, 7 years. Now you have to keep every patent application alive out to 20 years. This creates huge costs for the startup company. It creates costs for the patent office. It's incredibly wasteful because of what Lori just said, is that if you're not going to have a bungee cord of the ability to amend the patent and reframe it to the scope it should have, well, you have to keep other options alive to get that patent protection. And it's creating just lots of costs for everybody that really oughtn't be borne.
Well, I want to thank our panelists for their insights and comments, and I hope everyone had also a very good lunch. And we will continue the conference back in the auditorium in about 10 minutes. So thank you again.
Good job, everybody.